All right, still with me, Federal Executive Clemency Attorney Tammy Allison and Criminal Defense Attorney David Bruno. And I can tell you guys, wasn't a podcast guy until I picked up Serial, you know, maybe 10 years ago. I can't forget now. And I've been hooked on podcasts ever since. An amazing podcast. And as a result, continued to follow this story. Incredible iterations. Guy was granted a new trial at one point, but then the appeals court overturned it. That one was because there was an alibi witness that wasn't sought by his attorney. There was ineffective assistance of counsel, but they didn't feel, the appeals court, that it was enough to change the outcome of the trial, so didn't grant the new trial. So this guy's been going through lots of ups and downs. But David Bruno, the thing that jumped out at me about this, and gosh, this one is the one that makes my blood boil, is there was information, it's called a Brady violation, where there's information prosecutors have about possible other suspects that they either don't flag down, they don't investigate, but then they don't even turn it over to the defense so they can figure out what to do with it or maybe do some investigating on their own. And that's a big part of what's happening here.
Yeah, big part of it. Brady information is exculpatory information. It's evidence tending to support innocence. This is why it is required in state court, in federal court, in every court in the United States. It requires prosecutors to turn over this type of information. And specifically on a circumstantial case, this was a case where an individual who got the benefit of a plea bargain testified against him using unreliable cell witnesses to corroborate that single individual's testimony, and this is why he was convicted. Now it turns out that there are two other suspects, one in which threatened to kill the same victim. Also, these two suspects have sexually assaulted individuals, have hurt other women. I mean, it fits in the MO of the crime as well. And it is so exculpatory that it demands a new trial. And I have a problem not releasing him immediately. This should be speedy. When this motion was filed, there should have been an order, but apparently the procedure is a hearing. Let's wait for the hearing. This man needs to be out. And if there's going to be a new trial, let him out so he could gather his evidence and work on his defense.
Yeah, they still have to figure all that out. And like you said, the original conviction came on some questionable testimony from a friend of his who apparently he claimed on the stand, Adnan told him he did it, took him to the car where the body was, and he helped him bury the body. He actually, that witness, took the police to the car, so that made him credible. But the rest of it, there was no other evidence tending to point to Adnan Syed except this unreliable cell phone tower data that everyone knew was unreliable. Even said it on the paper that the telephone company sent over to prosecutors, said this is unreliable. But anyway, let's look at what the court has to look at once this information is presented to them. In order to vacate conviction, here's the legal standard. It could not have been discovered by due diligence in time. Okay, we got that. Creates substantial probability that the result would have been different. I think that's fair to say we've got that here. Also, the state's attorney receives the information that calls into question the integrity of the conviction. We absolutely have that. And the interest of justice and fairness justifies vacating the probation before judgment or conviction. So again, Tammy, let me ask you, it sounds to me like, well, first and foremost, it's the prosecutors bringing it, so that's powerful. It sounds to me like most of those standards are being met according to that statute. He's going to be out real soon, I would think.
You know, Michael, maybe not, because of the fact that, you know, this is, you know, the state prosecutor's motion, right? And let's all keep in mind the state prosecutor here is Marilyn Mosby, and she herself is currently going through, you know, pretrial motions in her own federal case of perjury and mortgage fraud. And the fact that she recently lost the election here in Maryland, it tends to question the timing of all of this. And it's highly unusual in these types of situations for a prosecutor to bring this type of motion before the court. Marilyn Mosby has done amazing things. I am a huge fan of hers. And, you know, her attorney, Scott Bolden, just put out a statement about her personal situation and her losing the election and her about to be out of a job. So again, with this motion, I think people do take into consideration some of those other outside influences, especially with the timing of this and the fact that it's the prosecutor bringing this motion, when typically in these types of situations, we see defense attorneys point out very laid out arguments as to why this individual's conviction and sentence should be vacated. But here, not only is it surprising, the prosecutor, this is Marilyn Mosby, not just any prosecutor.
And you know, I'm a former Maryland resident, Marilyn Mosby. I'm a fan of hers as well. David Bruno, she brings up a fantastic point. You know, these cases, while of course, you know, justice is supposed to be done and we're supposed to look at things a certain way according to the statute, sometimes politics do play a role.
Sure. I mean, look, this defendant exhausted his appeals. This went all the way up to the U.S. Supreme Court for cert, and they denied. He had nothing left except for this. And look, in the application by the prosecutor, they talk about there's this policy, and also recent history had unfortunately revealed system issues in the arrests, investigations, and prosecutions of minorities in Baltimore. There's a lot more to the case too. One of those suspects that I referenced, the vehicle was found, the victim's vehicle was found in his family member's property also. I mean, there's a bunch of things that should have been known to the jury, should have been known to the defense. And they also say that though that information was in the prosecutor's file and was not in the defendant's file.
That's right.
And that is why this needs to go back to start for at least a new trial.
But here, I want to take it a step further because I've had a couple of friends who we followed this case. He asked me, you know, how do you stop this thing, Tammy? How do you stop this type of thing where this information that could be exculpatory is not passed on over to the defense? Do you have to go after prosecutors to make this stop?
You know, defense attorneys have an obligation not only to their client that they defend, but also to the public and how the criminal justice system works. So making sure that they're preserving the record for appeal, making sure that at the time of trial, every single piece of evidence that's presented, the defense attorney is making a record that they have all the information, double checking with prosecutors, having conversations with prosecutors. Yes, it's the law, and yes, there are defense attorneys and there's prosecutors, but it doesn't have to be unnecessarily adversarial. So I do think from the very beginning part, in order to combat some of these inherent biases in the criminal justice system, sometimes you just gotta fake it till you make it and play nice with these prosecutors to figure out if they are holding something back from the very beginning, so we're not in a situation like this. In addition, this is not the only remedy for this defendant. Again, it's typical for a defense attorney to bring a motion like this forward, but it's also important to note that he does have to exhaust all of his judicial remedies before he is in a good position for clemency in the form of a commutation, which could result in him being favorably recommended to the governor of Maryland, where he could be relieved and have his sentence vacated in that form, which is a commutation, which is a form of clemency.
Interesting. So there's a, you know, he could absolutely go that route at some point with all this information that's coming out. And folks, if you have not listened to the Serial podcast regarding this case, I highly recommend it. All right, guys, stand by. We do have to take a break. Coming up next, we wanted to